Let's imagine that you receive an email from a potential client, and this potential client says that unfortunately from their living room, they watched an accident with sons and their brother. In the accident, they lost their brother and they lost one of their sons. They went to the mortuary to view their son's body hours after. They are now looking after their living son, which is causing them a lot of stress. As a result of viewing the accident, they claim, and as a result of viewing their son that they lost at the mortuary hours after the accident, they claim they have developed post-traumatic stress disorder. This potential client wants to know if he could possibly recover damages in negligence in English law, even though he was not part of the accident. Is it possible? Hi, I'm Denise, and you're watching Law with Denise. Yes, it is possible, but there are some requirements that this potential client would need to meet in order to have a successful claim. So there's some things we need to start off telling our client. And the first is that if he suffered mere grief or sorrow as a result of an incident, the court will not give damages for this. And this has been made clear in cases such as McLoughlin and O'Brien and Attia and British Gas. But in our client's case, he claims he's suffering from post-traumatic stress disorder, which is a recognized psychiatric injury, and it has been recognized in several cases, including Alcock and Chief Constable, South Yorkshire, 1992, and McFarlane and EE Caledonia, 1994. He does mention, though, that he is feeling stressed from looking after his son that is still alive. This we have to advise our client about because the court has been very clear, specifically in Alcock and Chief Constable, South Yorkshire, the Lords made it clear that damages will not be awarded for stress that one encounters or experiences as a result of looking after a loved one who has, for example, been involved in an accident. And we saw in Sean and Hampstead Health Authority, 1994, that the court was unwilling to award damages to the father who looked after his son for 2 weeks prior to his son's passing. So that the client needs to be aware of. But we can make mention or make it clear to him that with regard to his psychiatric injury, which he suffered as a result of viewing his son in the mortuary and as a result of viewing the accident itself, this will be recognized by the court. But there are other requirements that he needs to meet. And our client needs to know that for the purposes of the law, he will be recognized as a secondary victim, and that the type of claim he's putting in place is one for pure psychiatric harm. It's pure psychiatric harm because he did not suffer any injury, and he's a secondary victim because he's one who witnessed the incident. He wasn't actually involved in the accident. Now, what does this mean for him? It means that he has to satisfy some control mechanisms which were outlined in Alcock and Chief Constable, South Yorkshire, 1992. And these are 3 control mechanisms that he would need to pass with regard to the claims he's making for each son and his brother. And he needs to pass all 3 of these control mechanisms in order to be successful. So what I mean is, for son 1, he would need to pass all 3 to recover damages for that. For son 2, he needs to pass each control mechanism to recover damages for that. And also for his brother, he would need to pass the control mechanisms to recover damages for that. Now let's break it down. What exactly are these control mechanisms? The first one is the proximity of relationship. The court wants to see that there is a relationship of close tie and love between the secondary victim, who is our client, and the individuals involved in the accident. And when it comes to the relationship between him and his sons, he should be able to meet this control mechanism. And this is because there is a presumption in the law that there is a close enough relationship between parent and child, and also between spouses. So when he goes to court, when he starts his case, the court will presume this. So he should pass his control mechanism. Unless the defendant has some evidence to rebut this presumption, he should be okay with regard to his relationship between him and his sons. But when we look at the potential client's relationship with his brother, things are different, because the court does not presume that there is this relationship of close love and tie between siblings. So what would our potential client need to do? He would need to demonstrate that there is that, or there was that close tie of love and affection between him and his brother in order for him to pass this control mechanism with regard to that specific relationship. And it has been done because it was done in McCarthy and Chief Constable of South Yorkshire, 1996. So we can tell the client that it is possible, but he will need to demonstrate that in court. Now, in addition to this proximity of relationship, another control mechanism that he will need to pass for each person is the control mechanism of proximity in time and space. Now, what are we talking about here? We're talking about whether or not the client actually viewed the accident. So if the client was simply told about it, but they never viewed it, then this would not satisfy this control mechanism. But in our potential client's case, he should be okay because he actually saw the accident. Could he add the fact that he saw his son in the mortuary hours after to his claim? Yes, he could, because the court recognizes what we refer to as the immediate aftermath principle. And this is a principle which recognizes that in some instances, the secondary victim may view their loved one hours after or sometime after the incident. And you can still recover damages for that. Now, the court will look at the circumstances and they will determine whether or not they think you should recover damages. In some instances, they have awarded damages for viewing of a loved one after the incident. For example, in McLoughlin and O'Brien, the mother did see her family in a state 2 hours after the actual accident occurred. But in Alcock and Chief Constable of South Yorkshire, when the victims saw their family 9 hours afterwards, the court was unwilling to recognize this as sufficient for passing the control mechanism of proximity in time and space. We've seen other cases in which the courts have said that the viewing of the relative in the mortuary hours afterwards is enough to meet the control mechanism of proximity in time and space. Our potential client needs to be aware that with regard to this element or decisions can be quite different, but nevertheless, it is not so much an issue for him because he actually saw the accident. So he should be able to pass this control mechanism based on the fact that he actually saw the accident, which involved his 2 sons and his brother. Now, the other control mechanism that he will need to satisfy is the control mechanism of proximity of perception. And the potential client should be able to pass this control mechanism of proximity of perception. In Alcock and Chief Constable of South Yorkshire, the secondary victims were not able to pass this control mechanism because they saw the incident on the television. But in our potential client's case, he saw it with his own eyes. He didn't see it on television. In Tree and Palmer's, in that case, the mother actually had visions and nightmares about what could have possibly happened to her abducted daughter before the police found her daughter and before she actually saw the horrifying scenes of it. So in her case, she didn't meet the control mechanism of proximity of perception. But with regard to our client, he should be fine with passing this control mechanism. So to sum up, we need to make clear to our potential client that he needs to demonstrate that he has suffered or is suffering from post-traumatic stress disorder, and that the post-traumatic stress disorder is as a result of what he saw, so the accident and the viewing of his son in the mortuary. We also need to make clear to our potential client that with regard to the stress that he's suffering as a result of looking after his son, the court is unlikely to award damages for that, right? So he needs to be clear about that. We also need to make clear to him that there are 3 control mechanisms that he needs to satisfy, and he needs to satisfy that for each victim that he saw, so his 2 sons and his brother. And we need to make clear to him that with regard to the control mechanism of proximity of relationship, he will need to provide some evidence to demonstrate that there was a relationship of close enough ties of love and affection in order for him to convince the court that he can pass this control mechanism with regard to his relationship with his brother. But with regard to the relationship with his sons, this control mechanism should be easily passed because the court presumes that there is a relationship which is close enough to pass it when we look at parent and child relationships.